Okay. Hello, everyone, uh, and welcome to our today's episode. As you know, today we will talk about the IP's critical role protecting your innovations in developed products. Today, our guest is Sarah Holland, and I want to introduce her briefly. So, Sarah is patent attorney at Potter Clarkson, UK. She provides support to numerous synthetic biology and industrial biotech companies founded by early stage scientists spanning the UK, Europe, and beyond. She works alongside these companies to identify their IP, develop a solid IP strategy, and prepare them for fundraising. Welcome, Sarah, and we are glad to see you here today.
Thank you for having
If you
me.
have some words, if you have some words before we start, so floor is yours.
Yeah, so I was just going to say, I think a lot of you are still in an academic setting. So before I became a patent attorney, I was a PhD, and then I was 33 basically until I finished my academic research. I was a postdoc for quite a while until I realised actually I'm not going to get my own lab. I needed to do something else. So I've got a lot of years of academic research and molecular biology. So I think that's what helps me in my work today, having that kind of understanding of the technology that my clients are working with. But also, yeah, an academic career wasn't for me in the end, and I've been doing this now for 10 years, and yeah, really enjoy it. So
Okay, thank you. And let's start. So, as a scientist, when we find something new, when we have new findings, we are so excited and happy about it. But the next feeling that follows this is fear. That when we introduce our findings to the scientific community or public, so there is a high chance that someone would take it and make it their like own innovation. So, however, we know that this fear stems from the lack of knowledge of IP or idea protection. So today we want to kind of tackle this problem. That's why the first question that I would like to ask from you that how can we protect our research findings through patents or other IP mechanisms?
yeah, okay. So for me, going a step back from that, I think for me the first thing as a researcher, when you find out something new and exciting, for me the first thought was, oh, I'm going to publish it in a paper. It's not the thought of, oh, actually this could be impactful on the world and I should think about commercializing it or think about protecting it, like you say now, in a way that means either I can develop it myself or it can be licensed out to a third party for them to develop. Because I think the thing that I really didn't realize when I was in academia was, or the thought process that I had was, I'm going to publish it. Some other party is going to read my paper and do something amazing with it. That's what I kind of thought happened. But in the real world, if you publish it without thinking about protecting your intellectual property, you can't get those patent rights to it, because to get a patent granted, it's got to be new. And if you've published it, it's obviously not new anymore because you've already told people. So by publishing it without thinking about protecting your intellectual property, it might be the best idea in the world, but a company's probably not going to invest the time and money in developing it into something that people can use or can save the planet if you can't get the IP to it. So I think if you've got that idea and you're at that stage, if you found something new, the first thing is actually, is it going to be useful to the world? Should I think about protecting my IP? And if you're in a university setting, which I think probably a lot of the audience are, it's going to depend very much on where you are. Different countries have different rules, but most of them, with the exception, I think, really being Sweden, inventions made, so you've made an invention, you've got a discovery, in the university will often belong to the university. So there are some exceptions, and sometimes if you're a student, so you're a PhD student or you're a master's student, you may own that intellectual property yourself. And I think that's the case in Sweden. And it's the case in the UK for some places. So you would need to check your kind of specific arrangements with your university, what happens. But more often than not, the university will at least have some claim to your invention. So particularly if you're a postdoc and you're actually properly employed as an employee. So I spend a lot of time speaking to people who maybe just left academia, maybe some PhD students who want to do something with their research. They want to build a business around their research. And I have to tell them quite often, probably you're not allowed to do that, because that idea you want to build it around actually belongs to the university. So your first the first place you really need to go to is your tech transfer office and speak to them. They can help you work out who owns what, whether they should own it, you own it. If you're in a situation where the university says, yes, you own it, we're not interested, get that in writing. It can just be an email, but get something in writing, because if somebody says, Sarah, yes, this is your idea, you can do what you want with it. When I go to try and talk to investors at some point, they're going to want to know that university is not going to come after you for ownership of the IP. So the first thing to do is talk to your tech transfer office. They may want to fund a patent application to it themselves. They may cover those costs. They may say, no, we're not interested, you do what you want with it. But that's definitely the first place to go. And then the next thing to think about, so if we're thinking about, there's different types of intellectual property. So I'm a patent attorney, so I'll deal with patents, and patents cover it's like the clever bit, how things work. It's the invention. So it's if it's a new antibody, it might be around its sequence or something specific about it that makes it better than other antibodies. There are other intellectual property rights which are more relevant to other kind of non-science-based sectors. So there are design rights which protect how something looks, so it can be a shape. So a lot of the medical devices maybe have some design right protection around them. Then you've got things like copyright when you're thinking about some innovations around software. But for science-based things, innovations, it's mostly patents. So if you've got your idea, find out who owns it, and then think, actually, is it something that I could get patent protection for? And the university can help you with that, or you can seek independent advice from somebody like me. You can talk to people like me anyway, and you may want to talk to somebody independent if there's a dispute over the ownership. So if the university thinks they own it, you think you might own it, you want your own advice. But somebody like me can help you work out whether your invention's novel under the patent law. So is it different to everything else out there? And it only has to be one difference. So sometimes maybe you've got a new method of cultivating cells, and the only difference between your method and the earlier methods is a different pH or a different temperature. That difference is enough to make it new. So it's new, which is good. And then we have to think about inventive step. So your invention's new. That thing that gives it its newness, does that also make it inventive? Is it clever? And the way inventive step is assessed by patent examiners is generally similar. They can combine different numbers of documents in different places, but most of the time you need to ask yourself, so somebody who's a bit, not robotic, but we have to look at inventive step through the eyes of somebody who is probably not yourself, because you're all paid to research, it's your job to think inventively. So you're an inventor. But we're looking at this kind of skilled person who's a bit less creative. They can follow instructions, they can follow protocols, they can read papers, but they are not going to say, look at 2 papers and go, oh my God, this is a really good idea that I've just come up with. They can't do that. So if paper 1 says, go and read paper 2 and do what it says there, they can do that, but they can't make that leap without that connection. So you've got your idea, looking at it through the eyes of this skilled person, was it obvious? Is the question we have to ask in like the patent world. So it's new, but was it obvious based on all the documents out there that have been made publicly available? And it's not just documents, it's poster presentations, abstracts in books when you're going to give a talk, websites, blogs, anything that's publicly available before you file your application can be cited against you and stop you getting a patent. So in the academic world, this is very important because everybody goes and gives talks about their stuff all over the place, and that is generating prior art against something you might want to file on later.
Okay, thank you so much. And actually, the next question, you already answered it, and I want to a bit just ask something additional to this. That when we patent the idea within our location, like within our country, then as far as I know, we should also consider, for example, if we are living in Europe, if we want to patent our idea within Europe too. And then if we want to do international patent. So could you please also talk about briefly about this procedure, and also this patent fees should be there?
How much it costs?
That cost,
Yeah. Okay. So patents are a territorial right. So if I've got a patent granted in the UK, it gives me the right to stop people within the UK from making my invention, using it, importing it. That's only in the UK. Obviously, the UK is not the whole world. So if I'm a company based in the UK or wherever, I probably will want to get a patent granted in the US. Europe has its own kind of patent system where it's one application and examination process, but then you get protection in a range of different countries across Europe. A lot of companies are interested in places like China, Japan. So you need to think worldwide, and you also need to think. It's hard because at the early stages you haven't got much money, but you have to think down in a 2 or 3 years' time. You might want to partner with a big pharma company or a big whatever manufacturer, and if their main markets are in China and Japan, and you've not got protection there, that might make your company less attractive. So you need to have this bit of a longer term vision as to who your future partners might be and where they might want to file. But the filing system normally starts off with filing one application in one country, and it doesn't really matter where that is. So it can be your own home country. The day you file that, it's called your priority date, and I've written a few things on that recently, but your priority date really is kind of your marker in the sand, and when your patent's examined, the examiner can cite anything published before that date against you. As soon as you've got that priority date, anything published after they can't cite. So this is really useful for, say, you're in academia, you've got a manuscript ready to submit to Nature, but you think, oh, I want to file an application. You can file an application, and then you can publish your paper the next day. You don't have to wait. As long as you've got application filed, it's fine. So we'd normally file one application wherever, and then within 12 months of that, you could file a separate application in China, Japan, the US, or there's this international PCT filing system, which means you file one application today, one international application in 12 months, and then another 18 months from that is when you need to decide. So that's a good way, especially for startups, for anyone really, to kind of delay that decision-making process. So I've got 2.5 years to decide, actually, China's really important to me. So that's and then once you've got your application in each country, that's when a patent examiner will look at it. So it will be examined in the US by a US examiner under US patent law. It will be examined in China by a Chinese examiner under Chinese patent law. So the general principles of novelty and inventive step are very similar, but there are slight differences. So you might get one patent granted in the US that might look a bit different to what it looks like in China. And then the costs, I think, again, that's going to vary depending what country you're in and what the kind of local fees are. But in the UK, I guess the biotech application could be anywhere between £8,000 and £10,000 to file that first application. Then the international application the international application a year later is probably about 5,000 or 6,000 maybe. It all depends on how big it is, because there's fees associated with how long it is and all that kind of stuff. But I think the thing to think of is at this early stage, I know you've not got, as a startup, you've not got loads of money, but your intellectual property, your ideas and your innovations, that's all you've got. So you need to make sure they're protected. Because if somebody wants to buy your company, that's what they're buying. They're not buying the big factory that you haven't got. They're not buying all the equipment. They're buying your idea, really. So.
Okay. Thank you so much. And the next question is actually how do we enforce our IP rights if someone else infringes upon them? And I will support this question with just a very, very simple example that I'm sure that, for example, let's say not in science, but let's say in fashion industry, the well-known companies, well-known brands have already patented their products. However, we see lots of fake products of their brand in the market. And in this
Yeah.
case, it kind of leaves me the question that what are the is maybe does IP have it's like a strong how to say is that it's not enough strong to take some actions
Yeah.
towards those people, or just do we wasting money on that, just how this happening?
Yeah. Okay. So patent rights, it's not a criminal thing. the police aren't going to come and knock on your door if I used CRISPR, that's protected by somebody's patent. If I use that, it's up to the patent owners to come after. It's up to the owner of the IP right to kind of police it and look out for people who may be using their technology if it's patent protected. So on the one hand, there's an argument that if you're doing something in-house, it's hard. Like if I own a patent to a method and you're doing it in your lab, how am I going to know? There's an argument sometimes around it's hard to enforce some types of patent claim. But I think patents do have intrinsic value in their own right. They're attractive, make you attractive to investors, and it's something tangible that you've got that protects your innovation, and you can enforce it. So sometimes you might be aware of a company that all of a sudden they're selling a certain product, and you have a good reason to think they might be using your process. Then you can contact solicitors and lawyers to kind of do a bit of discovery and try and get some information for them and work out if they're using your technology or not. Sometimes it's obvious because they're making a product and you can see it on the shelf, you can buy it and test it. So it's very much up to the patent owner to enforce the rights. And quite often, even having a patent without enforcing is enough to stop people from doing things. So I work with a lot of early stage companies, and we quite often do, well, everybody needs to think about it to some degree, but freedom to operate exercises. So if you've got a technology and maybe it's a PCR based method, I might have got patent rights that stop you doing what you're doing. So when we talk about freedom to operate, that's something for you to do to check if I want to make my commercial product and what I'm doing day to day, am I infringing somebody else's rights? And sometimes when you find that you are, you stop because you think, I don't want to cause trouble, I'm going to find a way around it. So just by having that patent right itself can deter people and keep your space clear. I think in the kind of what you're talking about, the clothing industry, I think we're talking more about things like trademarks, which is not, I'm a patent attorney, that's trademarks. But from what I understand, if we're talking about maybe the high-end trademarks and the luxury brands, I think the reason they don't probably go after the market traders who are selling knockoff Gucci handbags, I think they're less concerned because somebody who will buy a knockoff handbag at a market is not somebody who would ever buy the real product. So they're not kind of competing for the same customers, if you know what I mean. Also, there's probably just so many of them, but I don't know. I know a lot of my colleagues work in the area of brand protection. But I think, having intellectual property rights per se makes you attractive. You've got something that actually says, it's kind of turning your kind of mental idea into a thing. Got this patent, and then you can enforce it and you can clear your space.
Okay, thank you so much. And I think we have already answered the last proposed question as well.
Oh, sorry.
That can be used. That can be use our research findings to start business, and what are the IP implications of doing so? We have, I think, already answered, but if you have some additions, you are welcome to mention them.
Yeah. So obviously you can, and so going through the university and using those research findings, it's called the spin-out process, or I can't remember what they call it in other countries. In the UK, we call it spin-out or spin-off, I think some countries do. So that's a company that's kind of gone through the university, and the company is a separate entity, but it licenses the IP that you generated in the university. So this is like for the situations where people say, I want to do something with my idea, and I have to say, well, the university owns it, so maybe you want to go through a spin-out process. In terms of an idea, if we talk about can you patent an idea, you can't patent an idea. It has to be an invention, it has to be kind of practical. So in the biotech field, you will normally need some sort of data. If you're doing something in engineering, you don't really need to have made the thing. So if it's a gadget, the laws of physics say if I put this thing and this thing together, it's going to work in a certain way. So you can get away with drawings. But in biology, if you've got a new panel of biomarkers for diagnosing cancer or an engineered microbe to make a certain product, you have to have made it or have to have done something enough so it's plausible that it should work, because biology is inherently unpredictable at the minute anyway. So you have to have some data to give the examiner some kind of comfort, I suppose, to say, yes, I've done X and Y, therefore Z should work.
Okay. Thank you so much. My question is already like finished. I don't have any question left.
Oh, I'm sorry.
And yeah, and as I can see, there is no comment from the public stream. So yeah, end of our session. Thank you so much for being here today with us. It was such insightful talk, and I got to learn like so many things here. Also, I hope that our listeners also learned something new about IP. Uh, okay, we have the question.
Good. Go for it.
So, Ricky asked that when speaking with large companies about the invention we are developing, is there a good way to speak of the specifics without giving away the proprietary IP?
Yeah. So, like I said, if you filed a patent application and you've got it on file, then you are much more able to speak freely about your innovation because you've already written it down and it's got a date. So you can talk about what's in the application. If you haven't got that far yet, then really any discussions you want to do, especially with anybody really, but I don't know. I hear some things sometimes maybe about big companies hearing things and then taking it for themselves. So you want to kind of have a what we call a non-disclosure agreement in place. So having that and making sure it's got the appropriate terms in place means I can talk to you in some depth about my invention. You're under an obligation of confidentiality to not steal it, tell anybody else about it. The only problem with that kind of contractual confidentiality is I can't physically force you to not tell people. You could tell people, you could publish it all over the internet. If I've not filed my application, then that's my idea gone. So it's always better, ideally, to have something on file before you start telling people. Then if you haven't got that far, then make sure you've got an NDA in place. And also, sometimes you don't have to give away all the details, even in a more quite in-depth discussion. So it might actually be that when it comes down to it, the really clever part of your invention is, like we said, maybe a temperature. You can talk about your invention without telling them it's the temperature. It's a new way of blah blah blah. So I think this is the same when we talk academic talks at conferences. Quite often, I've done this for a few people where they've got a talk, they haven't filed an application yet, but we can just say, actually, just take out this bit. Or don't tell people what the proteins are. Just say there are some proteins. You don't have to tell people what the names are because that's giving away all the clever stuff. So there are definitely ways of being able to talk about your research and your invention in a useful way without giving away the secret information.
Right. Thank you so much. And thanks a lot, Ricky, for this nice question. And yeah, I don't see any other question for now. Um, yeah, I think that people don't have question about it anymore. So it means that we have answered, like we have touched every point of the IP. So it's nice. So thank you so much, everyone, and see you the next time, next Friday, with our exclusive speaker about exclusive topic. So see you and take care.
Bye.